Dobro jutro to all the Croatian friends. I really missed the opportunity of being able to visit Dubrovnik. That's a marvel in marble, and hopefully next time. What I would like to go into is mainly the practicalities. So what does an auction look like and what is needed to come to an auction? And I will do this within the context of the Untitled draft that some very strong legal minds are putting so much work in. So I will start with an outline of the conventions, and then especially three conventions. Let's see, I would like to go to the next slide. Yeah, there it is. Within the framework of these three conventions, the Unification draft will have to find its place. I will then, to give you a hint of what is behind the screens, what are we all working for, that is to service the practice of regular sales of vessels that will be recognized worldwide. And I will go into the system of Dutch law and Dutch procedural law. So you will have a taste of how this really goes into practice. And I think that will help you to get your mind around the necessity of such an instrument. And we will end in chaos. I hope we will be able to do that, where you all can unmute and we will conduct the public sale of a vessel according to the Dutch auction system. So I hope we have time for this, as I understand that many students are also participating, and I think the students can really use some extra money. So let's see if we can make somebody rich at the end of my talk. So the conventions, in the Netherlands national legislation, it all started with the Convention of the International Recognition of Rights in Aircraft. And as that used to be the original wording of this convention is in French and in Russian. And Article 8 states, the sale of an aircraft in execution in conformity with this convention shall effect the transfer of the property free from all rights which are not assumed by the purchaser. And here you see the clean title, because that is what we are after. We do not want lingering mortgages or havoc after the purchaser bought the vessel clean of all encumbrances. And this is the first theme I would invite you to follow also when we go into the next conventions. The second convention is the Convention on the Registration of Inland Navigation Vessels. And Mr. Estrella Faria went into this. The Netherlands are party to this convention. However, the Netherlands have not ratified the second protocol. And the second protocol is dealing with the effects of a forced sale. So when there is a public auction outside the territory of a contracting party. And the first paragraph of this Article 19 states that this shall be recognized in the territories of all other contracting states. And the second paragraph is interesting because it states that it shall not be recognized in a state where the final judicial decision rendered before the sale was performed, when that final decision was rejected, which makes a lot of sense and which is by now within the context of the EU and other international treaties quite obsolete, and we do not need this in a draft convention. The third convention I want to give some attention to is the International Convention for the Unification of Rules regarding to maritime liens and mortgages. So this is about ocean-going vessels. And in Article 11, it's again stated that if there's a forced sale, the vessel shall lose all liens, encumbrances, hypothek, mortgages, everything, unless the purchaser specifically accepts these. And an example would be that many times when there is a charter party in place, for instance with a time charterer, that the purchaser decides to take over, to accept the charter party, where he would step into the shoes of the owners. The third article is that when a vessel is registered in a contracting state and again has been sold by a forced sale, the port shall issue a certificate. And this is something that we also see in the draft convention. And this certificate is something that we do not know under Dutch law. And I will explain a little bit more on that when we come to the last convention, and that is the International Convention on Maritime Liens and Mortgages of 1993. And here you see in Article 12 about the same wording as in Article 11 of the previous convention. Again, free of hypotheks and charges, and a certificate has to be issued. Now, the Netherlands are not party to these two conventions, and that is not because there's a dislike for the conventions in itself. The only reason that the Netherlands have not ratified these two conventions is that they are changing the system of preferential rights. You know, one peculiar aspect of maritime law is that the right of hypothek or mortgage is not the highest ranking right. So if as a bank you would like to sell a vessel because you have 1 million to claim and the proceeds of the auction are 1 million, it may very well be that there's a salvage claim, there's a claim for general average, or there's a crew claim for unpaid crew wages. And all these three claims will take preference over hypothek or mortgage. And these two conventions are introducing new and other super preferential rights. And that is something that the Netherlands did not want to adhere to. And it is also good to know that the system of ranking, as it is in the Netherlands, is copy-paste, is exactly what this system is in the Geneva Convention, in the very first convention that I mentioned, where the second protocol, which deals with recognition of the effects of the public sale, has not been ratified by the Netherlands. So let's go into the proceedings. This is all from Dutch procedural law. A public sale can be performed by a public notary, a civil law public notary, or before the court. And experience has taught us decades ago that a public sale conducted by a public notary, which is perfectly feasible and viable and legal, is not, or with great difficulty, accepted by registrars in common law jurisdictions. They have a different view of what a public notary is. It is not the Roman law public notary, and they would very much prefer that an auction is conducted before the court, which is what we do in the Netherlands when it concerns foreign registered ocean-going vessels. In order to come to such an forced sale, you would of course need an enforceable title, which can be contained in a mortgage deed or in a court decision from any foreign court, as long as it is recognized and enforceable in the Netherlands, or from any local or foreign arbitrational tribunal, as long as it is recognized and enforceable in the Netherlands. What I would normally do is commence the actions against the vessel with a conservatory arrest. And at the moment when the enforceable title is notified to the arrestee, to the owners or bareboat charterers of the vessel, then the execution commences, the enforceable time period commences. And at that moment, all costs that run to maintain the vessel will also be super preferential. So that's the fourth super preferential right, which makes very much sense, because in actions like these, an enforcing arrestor is, of course, as an advocate, I am then working for my client because I want the vessel to be sold. But there's also a public interest that will need to be protected. And when an arrestor takes the lead to come to a public auction, in a way he represents the interests of all arrestors and all interested parties to the vessel. As an advocate, I would then have to file two petitions to the court, two separate proceedings. The first one will be asking the courts very respectfully to pick a date in the agenda for the auction to be conducted. And then customarily, we will ask for 30 days to fulfill certain formalities. And the other petition to the court is that we are asking the court to appoint the newspaper that is to be applied in the country of registration. So by now I have very close relationships with the local newspapers in Panama or in Liberia, because that is dictated by the law. And I will now go into these formalities a bit deeper. So the first formality, we know this from common law jurisdictions. I know in California in the United States, you have a warrant, which is a document that has to be stapled or glued to the bridge of the vessel. In the Netherlands, the same thing. Anne Venner has showed you several posters, advertisements of public sales. And in the Netherlands, this poster, this advertisement, must be attached in court at the public announcements board and on the vessel itself. Then one or two local newspapers in Panama or Liberia must also advertise the sale. And as a matter of customary law, because the law says the advertisement has to be done in line with local customs. And in the Netherlands, that means that we also advertise in a Dutch national newspaper and or in Lloyd's List or internationally read newspapers for the shipping community. 30 days before the arrest, as an advocate, I have to file to the court the auction conditions that we write ourselves, of course, within the limitations of the law, and a signed declaration by myself that all formalities have been met. And these formalities include providing the court with a list of all known interested parties, owners, charterers, mortgagees, and all the other arrestors, and that they have been notified in writing of the day and the hour of the sale. And the same goes when the sale has taken place. I would then have to inform all interested parties that the sale has taken place. And then the last time period starts, and that is where the proceeds of the sale are to be divided amongst the arrestors. And that is usually done within a couple of weeks, but if claims are contested, it can take a bit longer. So what I would like to do now, as Anne Vennig warned us against, we absolutely do not want chaos and confusion that is to be avoided at all costs. But what I would like to do now is invite some chaos, but no confusion. So this is the case. There is an auction of the motor vessel, and the value is about 600,000 US dollars. And your client, so all those attending this Teams meeting, you're all advocates, and your clients have about 1 million to spend, and you want to buy the vessel as cheap as possible. And I will now explain bidding proceedings. If you win the final bid, if your client gets the vessel awarded, he will have to pay the cost of the execution, which is about 10,000 in this case, and he will have to pay for the bid premium. And I will explain that later. And of course, the third element, your client will have to pay the purchase price. Now the system is as follows. This is called the Dutch auction. So this has evolved throughout the centuries, throughout the tulip craze, and it's a very cunning system to maximize the outcome. We have 2 rounds of bidding. The first round is a common auction where you will shout out amounts, topping the previous amount. And when we have reached the maximum, which is for you to decide, the highest bidder in this first phase will get a bid premium. He can take home 5% of what his bid is. So that is lovely. We're only then halfway. Then the second part of the auction will start. And there I will call out the numbers. So you will not call out numbers. I will do that. I will start at 2 million, and then I will work my way down until 0, up till the moment that somebody shouts, mine. Mine, Dutch for mijn, is a it's very rudimental, and it is your claim that it is your vessel. And at that moment, the auction ends, and you will have to pay the 10,000 for the cost of the execution. You will have to pay the bid premium, the 5,000 for the maximum in the first phase, and you will have to buy the purchase price, which is the total of up and down. And if you're confused, so be it. Even advocates make mistakes here, and then they're in deep trouble because their mandate is only up to 1 million. So be careful here. So let's start. I will invite all of you now to unmute. Is everybody unmuted? Can I have a first bid?
500,000.
500,000. Anyone more than 500,000? More than 500,000.
500,005.
500,005. More than 500,005.
500,045.
500,045. Anyone more than 500,045?
500,050.
500,050.
550,000, that is.
550,000. Anyone more than 550? 550,000. Someone
555.
Again?
555.
555, more than 555.
557.5.
Any more than 555, 7.5.
600,000.
600,000. There we go. I lost you. You can still hear me?
Yes?
Yes.
Okay. Let me stop. Yeah, there we are. So more than 600,000. Going once, going twice, going thrice. 600,000. So now we know what the bidding premium is. That is 5% of 600,000, which is 30,000 US dollars, if I'm correct. Am I correct? I'm a lawyer, I can't. Good. So now you know you will have to pay 600,000 plus 30,000 plus 10,000. So you know what your budget is. And now we will start the second part. 2 million. One more thing. If you shout mine while I am speaking, the previous amount goes. It is not the amount that you interrupt. Yes? So 2 million, 1,800,000, 1,600,000, 1,400,000, 1,200,000. Carina, Peter, and Diana, and Angela, you are missing out. You are.
I thought I was muted. I tried to bid, but everyone was.
I see many muted.
No, I'm here.
1,600,000, 1,400,000, 1,200,000. 1 million. I will now go down in brackets of 100,000. 1,900,000, 800,000, 700,000, 600,000, 500,000. I will now go down in brackets of 50,000, 450,000, 400,000.
Somebody said mine.
Yes, I did.
Oh,
Nada.
Igor is buying.
I'm buying.
Okay. So,
how much was
And I will hire Peter and Diana for my legal department.
yeah, because I'm afraid you exceeded the mandate of your client, but I'm sure you are insured. And I wanted to give you a bit of a taste of how nerve-wracking it is, because you absolutely do want to buy the vessel, but you don't want to shout mine too early. And I think this is an argument to be moderately conservative, because algorithms or game theory probably cannot better a system that has evolved throughout the centuries. And this is the system that we would apply in the Netherlands when we would conduct the auction of a vessel. So I've talked with you a little bit about the 4 conventions where this draft convention would have to find its footing. I've explained to you a little bit on the allergy that some jurisdictions have against conventions infringing on their system of ranking, for instance. And I have explained to you what the formalities would be and how a Dutch judicial sale would be performed. And this can be done in 6 weeks, minimum 2 months after the initial conservatory arrest. So I thank you very much for your attention, and I would like to give the floor back to the moderator.
Many thanks, Harmen. Wonderful presentation. I have